Well, this morning, more sweeping cuts of the federal workforce, this time at NOAA. Sources tell CNN that 800 agency employees have been tapped for terminations, with more firings possible today. But a federal judge has now granted temporary relief for some of the organizations fighting President Trump's dismantling of the government. He ruled that the mass firings of probationary federal workers is likely unlawful, writing, quote, "The Office of Personnel Management does not have any authority whatsoever under any statute in the history of the universe to hire or fire any employees but its own." CNN's Renee Marsh joins us now. Wow, this judge did not mince words. What is the immediate impact of the decision?
Well, this judge specifically blocked the Department of Defense from firing probationary employees that they were planning to fire this Friday, which is today. But really, Pamela, it's unclear what the full impact is going to be on the thousands of probationary employees at other agencies who have already been fired. What this ruling really did was essentially state that OPM does not have the authority and overstepped its authority to essentially instruct these agencies to fire or how to manage their own workforce. And that's what the judge was saying in that quite interesting quote here. It's quite forceful quote here where he says there is no statute in the history of the universe in which OPM has the authority to hire or fire employees other than their own. But at the heart of this was this February 14th memo that essentially OPM told these agencies to identify employees who were not considered essential and send separation letters to these individuals. These probationary employees are people who have been on the job for less than a year. Now, the Trump administration's lawyers argued that we made an ask. We didn't force these agencies to do this. The judge was not buying that. However, the judge did acknowledge that agencies themselves do have the right and authority to fire probationary employees. And this judge also said that he didn't have the power to reinstate these probationary employees, the thousands of them that had already been fired. So again, unclear what the full impact of this ruling will be, but it is clear that the OPM doesn't have the authority to tell these agencies to do this.
All right, Renee Marsh, thank you so much. Great to see you.
A federal judge is blocking efforts by the Trump administration and the Department of Government Efficiency to slash the federal workforce. Now, the judge in San Francisco ruled the mass firings of probationary federal employees are, quote, likely unlawful. Now, labor unions and nonprofits are suing on behalf of thousands of probationary employees who have lost their jobs. I want to bring in Kevin Owen. He's an employment attorney who represents federal workers. Thank you for being here. To this point, you've compared this initiative to the kind of disruptions that are typically caused by government shutdowns. What do you mean by that?
So in the Chico memo that was issued by OPM 2 days ago outlining these mass layoffs, what the OPM is saying is that employees who are typically not designated as essential during a lapse in appropriations are the ones that are going to be targeted for these mass layoffs. And in 2016, we saw 800,000 federal employees nationwide laid off during the lapse in appropriation for a government shutdown. And so what Americans can be looking for here is the type of shutdown that lasted in the fall of 2016, which closed national parks, closed Social Security agency offices, and really deprived Americans of the federal services that they're used to.
And, one of the other things you said previously is that their plan at this point is to get sued. What do you mean by that?
So they're not going through the normal processes legally that you would expect to happen by law, rule, or regulation. What they're doing is they're taking steps that are clearly unlawful on their face, taking thousands of employees out of their jobs, and then the employees are going to have to sue. The plan then appears to be to lose the cases, potentially have to pay out, but at that point, all of the federal employees are off the rolls, and they have gotten what they wanted in the interim, which is to reduce the federal workforce by 50%, maybe even 65%.
So you represent some of these federal workers that could be affected or maybe have been affected, but what are you telling them legally? I mean, what options do they have here?
So a lot of them are still on the rolls, and so they don't yet have the right to file the lawsuits. We are waiting until something next happens to take them off the pay status. And at that point, we are looking at class action cases, consolidated appeals to the Merit Systems Protection Board, dozens and maybe even hundreds of lawsuits to be filed within a couple of weeks.
And so obviously we're keeping an eye on this ruling significant. Obviously appeals play into this process as well. But are there specific rulings that you have your eye on, or specific cases that you think are going to be especially significant in regards to some of the workers that you represent?
Yeah, the top two are the federal court case out in San Francisco of AFGE versus OPM that just came out last night with that temporary restraining order. And the one that I'm mostly following is the temporary restraining order that was issued by the Merit Systems Protection Board, which is a federal agency that deals with these kinds of cases, a couple of days ago, ordering restraining orders at the request of the United States Office of Special Counsel. There are administrative procedures and administrative agencies that haven't really even gotten into working these issues, which are going to be very central and important to addressing these issues going forward.
Kevin Owen, really appreciate the time. Thanks for being here.
Thank you for having me.